Ladies and gentlemen, this is the time set for your arraignment. The purpose of an arraignment is to notify you of the nature of the charge against you and to advise you of your constitutional rights. When your case is called, you'll be asked to enter a plea to the charges against you. Your plea may be either guilty, not guilty, or no contest. In a few moments, I will be reading you your constitutional rights. It is important that you pay attention because later I'll be asking you if you understand your rights, and if you plan on disposing of your case today, you'll be asked to waive or give up these rights. You have the following rights. You have a right to be informed of the charges against you, to receive a copy of the complaint, and to have the charges read to you. You have a right to the advice and assistance of an attorney at all stages of the proceedings. You have a right to a reasonable continuance, to hire an attorney, or to confer with one before you enter your plea. If you are indigent and charged with a felony or misdemeanor, the court will appoint an attorney if you are unable to afford one. If an attorney is appointed for you, you may be required to pay a part or all of the cost of your attorney if the court determines that you have an ability to pay. A hearing may be conducted at the conclusion of your case to determine how much, if anything, you are able to pay. You also have a right to represent yourself if you wish. You are entitled to a speedy and public trial. If you are charged with a misdemeanor, you have a right to be brought to trial within 30 days of your arraignment. If you have not agreed to go beyond those time limits and the case is not started within those time limits, the case will be dismissed unless good cause is shown by the prosecution. If you are charged with a felony, you have a right to a preliminary hearing within 10 court days after your arraignment. If you're charged with a felony or misdemeanor, you have a right to a jury trial or a trial before a judge who decides guilt or innocence without a jury. You have a right to confront and cross-examine all witnesses who may testify against you. You have a right to subpoena witnesses and documents on your behalf and the right to the free assistance of the court to compel the attendance of witnesses and the production of documents and evidence on your behalf. You have the right to remain silent and not incriminate yourself. You have a right to testify in your own behalf, but you cannot be made to be a witness against yourself. You have a right to be released on reasonable bail pending your trial or preliminary hearing. When your case is called, you may enter one of the following pleas if charged with a misdemeanor. You may plead guilty, not guilty, or no contest. If you are charged with a felony, the court will enter a plea of not guilty for you. A plea of guilty admits the truth of the charge. A no contest plea has the same consequences as a plea of guilty in criminal proceedings. If you plead guilty or no contest, you will be giving up all the rights I have just explained to you. If you plead no contest or guilty to a misdemeanor, you have the right to be sentenced no earlier than 6 hours after your entry of plea and no later than 5 days after entry of plea. Unless you ask for the delay in sentencing, I will assume you wish to give up this right, and I will sentence you immediately. The maximum penalty on each misdemeanor charge, unless I tell you otherwise, is up to 1 year in the county jail, a $1,000 fine plus penalty assessment, or both. If you are not a citizen of the United States, you are advised that the conviction of the offense with which you are charged will most likely have the consequences of deportation, denial of citizenship, and exclusion from admission to the United States. If you are charged with a violation of probation, you have the same constitutional rights as if charged with a crime, except you have the right to a hearing within a reasonable time, and you have the right to a court trial only. If you are charged with an infraction, you have the same rights as if you were charged with a misdemeanor, except that you do not have the right to a court-appointed attorney, you have a right to a court trial instead of a jury trial, and you cannot be sentenced to jail. If you are charged exclusively with certain drug-related crimes, you may be eligible for one or more drug programs. You may also choose not to participate in a drug program and accept the court's indicated sentence. In a moment, each of your cases will be called individually.
Good morning. I am Deputy Public Defender Rashid Alexander. You are here today for an arraignment. An arraignment is a court appearance where the court will give you or your attorney a copy of the complaint. A complaint is a written document filed by the district attorney accusing you of certain crimes. It doesn't mean you committed those crimes. It simply means the district attorney believes they can prove those crimes against you. If you cannot afford a private attorney, the court will appoint the public defender. Now, please take a look at the upper right-hand corner of the document advising you of your arraignment rights and find your case number. If your case number begins with the letter F, you are here for a felony. If your case number begins with the letter M, T, another letter, or any number, you are here for a misdemeanor. For all felony arraignment, a not guilty plea will be entered on your behalf, and you will come back to court in about a week, and at that time, you will meet your attorney. On a felony probation violation, you will come back to court in 1 to 4 weeks. Typically, your case will be referred to the probation department. A report will be written, and this will assist the judge determine what the appropriate punishment should be. On a brand new misdemeanor case, you will come back to court in about 2 weeks. In some cases, the judge will make you an offer today to resolve your case. If you want to accept the offer, you should do so. However, if you have any concerns or issues in your case, you should ask for a lawyer. On a misdemeanor probation violation, the judge also may make you an offer today. If you want to accept that offer, you should do so. And again, on a misdemeanor case, if you have any issues or concerns, ask for a lawyer, deny the allegations, and you will come back to court in 1 to 2 weeks. Now, there's a blue sheet of paper on the desk in front of you, and that blue sheet contains all the numbers of the different public defender's offices throughout the county. If you have any questions or concerns, you can call the public defender's office, and we collect phone calls. Now, when your case is called, please come up and have a seat in front of the television. There is a black triangle on the desk. Please do not put your hand, paperwork, or anything on that triangle because it's a microphone. If you cover the microphone, the judge will not be able to hear you when your case is called. Also, please do not discuss your case with anyone other than your attorney. That includes family members, significant others, or loved ones. Any conversation on the phone or during a visit can be recorded, and anything you say during that phone call or visit can be used against you. So again, please do not, under any circumstances, discuss your case with anyone other than your attorney. And again, if you have any questions, please enter a not guilty plea or deny the allegations and ask for an attorney.